Hi everyone, it's Mallory. Let's start off by addressing the elephant in the room, and I definitely cut my hair recently. But besides that, let's go ahead and get to our case study today. So, in a civilization of rapidly advancing medical technologies, life-sustaining treatments have made it possible to carry a pregnancy to term while a mother is completely incapacitated. Cases similar to the one I will be mentioning have moral and legal significance and have the ability to set standards for how society views pregnant women in general. In this discussion, I will apply the case of a young woman named Janet to argue that a pregnant woman's wishes, including those made by her chosen surrogates, should be ineffective, and all ethical factors and principles should be maintained for the unborn fetus. Janet and her husband, Jack, were in an automobile accident where both sustained serious injuries. Jack died on the way to the hospital, and Janet suffered from serious head injuries. A month after the accident, Janet's physician offered a continuation of a persistent vegetative state as the best case scenario. As a nurse, Janet had thought about advanced care planning and completed her own advance directive, naming Jack, her late husband, as a primary agent and her parents as her secondary agent. In her notarized healthcare treatment directive, she had written, in quotes, "If she were to end up in anything like persistent vegetative state from which I'm not apt to recover, I do not want my life to be extended by means of medically assisted nutrition and hydration, ventilator, or other life support," end quote. As Jack, her husband, was already deceased, this decision fell upon Janet's parents. They spoke with her physicians, other family members, and even their priest, and decided to stop everything except palliative care. Janet's parents took the role of acting in Janet's best interest as surrogates very seriously, and having received a copy of the advance directives, determined that this is what she would have wanted. Plans were made to transfer Janet to a hospital unit the following day. But here comes the kicker. That evening, a resident physician noticed in Janet's chart that she was 9 weeks pregnant. Since Janet was not imminently dying, the resident researched the moral, legal, and religious implications of the pregnancy, where it was discovered that in the state of Kansas, a woman's healthcare directives about withholding or withdrawing of life-sustaining procedures in a terminal condition may not legally be in effect while pregnant. The next morning, Janet's attending physician opened the medical record to find a note. The declaration of a qualified patient diagnosed as pregnant by the attending physician shall have no effect during the course of the qualified patient's pregnancy. And this is Kansas 6528-103-4B rule. Upon reading this note, the physician called the parents and informed them that Janet's transfer would have to be postponed until proper legal ethical proceedings could be determined. So, the key people who will be affected by this ethical dilemma include Janet, her parents, her fetus, her doctor, and let's not forget about the hospital that is treating her. Since Janet is incapacitated, her autonomy is already compromised, where her decisions are based on documentation and surrogates. The ineffective advance directive puts Janet's wishes to die with dignity in a precarious situation, as the fetus itself has a stake in the decision because its life or death is dependent upon the decision made. Janet's parents would be emotionally and possibly psychologically affected by this dilemma. They want to act in their daughter's best interest, and prolonging an inevitable outcome may cause undue stress and emotional consequences. However, looking at Janet's physicians, where his decision could affect the hospital legally, but it could also affect his relationship with Janet's parents. The hospital and its administration also stand to be affected by this case. Due to the legal nature, lawsuits and possible accreditation loss could wreak havoc on the institution itself. So I know many of you are going to oppose my decision for the fetus to live and continue to decide on what's best for Janet. However, let's ethically look at some factors contributing to this case. Since Janet has an unborn fetus developing inside of her, her decision to be taken off life support conflicts with the significance of the fetus' right to be born and survive. Not to mention that if taken off life support would also go against Kansas's statute. When looking at the natural law theory and autonomy, which is defined that human beings possess intrinsic values that govern our reasoning and behavior, natural law maintains that these rules of right and wrong are inherent in people and are not created by society or court judges. As a healthcare provider, I would be competing with Janet's autonomy and going against her wishes, as well as the wishes of her healthcare surrogates. This action supports the fetus's right to live. We could also apply the principle of welfare in which restricting Janet's autonomy would benefit the fetus as well. I also want you all to consider the fact that maybe Janet had not anticipated a pregnancy. The issue of logistics arises for the care and health of the child after it is born. The case presentation does not give information about the fetus's condition or who would be responsible for it. Since Janet suffered minor injuries, it could be presumed that the fetus is in good condition. We cannot assume that Janet's parents would be responsible for the child, so the child could end up growing up in foster care or being adopted. Janet's physician, in my opinion, should follow the law. Janet never considered what if she were pregnant at the time of notarizing her advance directive, and one should be sensitive toward the needs of the fetus. The hospital and Janet's physician have the ethical duty to serve Janet, but are conflicted due to the legal limitations and ethical responsibility towards the fetus. Previously, there was a case in California where a woman was declared brain dead, leaving her family to make a decision for her. They were advised to remove life-sustaining treatments, but decided to carry out the pregnancy. The woman's twins were successfully delivered, and the mother has shown signs of improvement since then. A pro-life argument of the sanctity of life would view this recommendation very critically. And real quick, looking at a similar case in Texas back in 2014, there was also a woman who was around 14 weeks pregnant and brain dead, and the husband wanted to end life support measures. However, according to Texas Health and Safety Code 166.049, a person may not withdraw or withhold life-sustaining treatment under this subchapter from a pregnant patient. This provision supersedes any personal directive and or wish from a pregnant patient. It is important to have everything written in stone, and personally, I completed my living well and durable medical power of attorney when I first became a mom. I plan to revise it after this case study, as I would want my fetus to have a chance of survival if my husband were alive or my mother. I know that they would want a positive outcome from such a tragedy, and I thank you for listening to what I had to say today.